All right. Welcome back to an unplanned part two in our video discussing the Ashley Guillard's motion to dismiss and to uh, uh, have the judge undo the. I'm having a brain fart. To set aside, that's what I'm looking for, to set aside the memorandum decision dismissing her counterclaims. So like I said, it's unplanned doing a part two. I had computer problems last night as I was recording. I was an hour and 15 or so minutes in, and it didn't want to work for me anymore. And I don't want to redo that hour and 15 minutes, but I also don't want to edit the videos together because let's face it, video editing sucks if you don't have to do it. It would take me 2 minutes to do the edit, but then several hours for a video this long to render, even though it's just stitching two long clips together. So instead, we're doing a part two. If you haven't watched part one yet, go watch that. Makes sense, doesn't it? If you have not watched part one yet, hi, I'm Joe. I'm an attorney based in Utah. This case is in Idaho. Now go back and watch part one where I introduced myself as well. So, with all that being said, just going to ask you guys one question before we jump into the video. So, today something happened that I believe this is only the third time in my life this has happened. We got a new Beatles song. And completely by accident, coincidentally, I just randomly grabbed a t-shirt today, and it's my Abbey Road t-shirt. Massive Beatles fan. I can't underestimate the impact the music of the Beatles has had on my life. So to get a new song from them is just it's a monumental occasion. So I'm curious how many of you have already listened to it. It's called Now and Then. It's on YouTube. And anywhere else you get your music too. They released it as a double A side along with Love Me Do, which is kind of fitting. The first Beatles single released with the last Beatles single. And my thoughts are it's a good song. It's not Here Comes the Sun. It it I think for the Beatles it's relatively mediocre, which still puts it as a good song. I'm just not sure if it's a Beatles song. So give me your guys' opinions. But with that, let's jump back into it, picking up where we left off. So basically, we are in the section where Ashley's saying that the docket 49 the order dismissing her counterclaims is void because the court doesn't have subject matter jurisdiction over the action due to no damages, even though damages haven't been proven yet. So, in anything but a breach of contract or like actual property damage where you have estimates, like you wreck my car, I can present the body shop bill showing the exact amount of damages. With defamation, it's hard to put a number on damages. So for Ashley Guillard to say no damages, well, that's just her claiming no damages. Professor Scofield is claiming damages. That's why they're in court, to figure it all out. But so when we cut off, we had just finished discussing that Ashley Guillard claims that Professor Scofield's GoFundMe shows that her reputation hasn't been damaged and she wasn't at threat to lose her job. So, picking up with new stuff, Scofield falsely claimed that Ashley Guillard caused her severe mental distress and that she cannot sleep, cries often, and must take sleep aids like melatonin. Ashley Guillard does not know Rebecca Scofield, is not a colleague, is not a part of her social circles, and does not live in Idaho. So she says Professor Scofield falsely makes these claims. How does she know? How does she know that these are false claims? I mean, this is ridiculous. As she says, she doesn't know Professor Scofield, isn't part of her social circles. So how does she know it's false that Professor Scofield can't sleep at night? Did her tarot cards tell her that? I mean, this isn't an argument I'd make, because it's frankly, it's bad faith. You can argue Professor Scofield isn't damaged because she claims she can't sleep. Do you see the difference? It's just disingenuous. So she was a random stranger on the internet that conducted a tarot reading and psychic investigation. Rebecca Scofield is lying. But you're a random stranger on the internet who made 100 TikTok videos posted on the internet for the world to see. If you're a random person in your home doing a TikTok reading or a tarot reading, sorry, no TikTok, random person in your own home doing a tarot reading, and you say, looks like Professor Scofield did it. And then you move on and you don't do 100 TikTok videos, you're not getting sued. You haven't caused her damage. How does she fail to see that it's the TikToks? That's the issue. That's the issue. I mean, her complaints that Professor Scofield won't turn over her entire social media to Guillard, but yet, well, I gave her my TikToks. It's because the TikToks are the issue. Additionally, Scofield lacks sufficient evidence that Ashley Guillard, a random stranger, caused her severe mental distress, and not the fact that she, Scofield, killed the 4 University of Idaho students. She can't be serious. She can't. I mean, it's possible that in the time between the murders and the TikTok videos that Professor Scofield had a hard time sleeping, but that's because there was a murderer loose in the community. Everyone in Moscow was having a hard time sleeping. I mean, but who would have better evidence about the cause of her mental distress than Professor Scofield? I mean, she lacks sufficient evidence that this is what caused her mental anguish instead of killing the 4 University of Idaho students. Well, she's also the person with the best evidence of her not being the killer. I mean, the person with the best evidence of who did kill the students, at least from what we know, it's probably Brian Koberger. Guilty until proven innocent, or innocent until proven guilty. Bit of a flip there. But it, how? How? How does she not see? Is it because her tarot cards haven't told her? She's not psychic enough to see that. Well, it's because it's not a psychic thing. It's a human interaction thing. It's a human behavior to understand that being defamed will cause you mental distress. She, I just, every sentence I read makes me dislike this person more and more. Additionally, because there are no damages and no reputational harm, there is no valid claim for defamation. Ergo, no valid reason for pain and suffering. In the plaintiff's own admission in docket 10, in a defamation action, a plaintiff must prove that the defendant, 1, communicated information concerning the plaintiff to others, 2, that the information was defamatory, and 3, that the plaintiff was damaged because of the communication. Elliott versus Murdoch, Idaho 2016. A defamatory statement is one that tends to harm a person's reputation, usually by subjecting the person to public contempt, disgrace, or ridicule, or by adversely affecting the person's business. And that's Serkey versus Serkey, Idaho 2020. Yes, those are the general elements of a defamation action. The difference here is this is defamation per se. She doesn't have to prove damages to win. She has to prove damages to win damages. But that's a second issue, a different issue. And right now, this is seemingly a contested fact. So Professor Scofield says, I've been damaged. Here's how I've been damaged. Ashley Guillard says, no, you haven't. That's what litigation is. That's what litigation is. It's allegations competing against each other, and whoever comes out of that cage match alive wins. Right now, Professor Scofield is looking like Conor McGregor, and Ashley Guillard is looking like me. I'd get my ass kicked by Conor McGregor. I mean, let's face it. The plaintiff's reputation was not damaged by Ashley Guillard's tarot reading due to a lack of belief in the power of tarot and Ashley Guillard's psychic abilities. It's not the tarot reading that's the problem. It's the TikTok videos. Professor Scofield very much believes in the power of 100 TikTok videos calling her a murderer. That's the defamation. That's the problem. That's the issue. And of course, like her not believing in the power of tarot, that just bolsters her claim. That bolsters Professor Scofield's claim. If she said, well, Your Honor, tarot and psychics are totally real and totally valid, she's just not fine-tuned enough to do it this time. That might give the judge some question of, well, was she reckless to believe in her own psychic abilities? What was this, a reckless disregard for the truth? Whereas Professor Scofield saying tarot cards are a bunch of bullshit and it would be reckless for anyone to put so much stock into tarot cards that they'd go on the internet and make 100 TikTok videos calling someone a murderer. So this is not an argument in Ashley Guillard's favor. It's not the gotcha that she thinks it is. It's complete lunacy. Oof. The statements Ashley Guillard made were not believed by anyone who impacted Scofield's personal and professional life. Scofield was supported by strangers, personal connections, and professional connections, and increased in popularity. Even the court fraudulently ruled that the accusations Ashley Guillard made about Scofield, based on the tarot reading, was, in this context, clearly baseless and are likewise not facially plausible under Twombly and Iqbal. Exactly. Are you arguing in favor of Professor Scofield here, you moron? You made clearly baseless statements that are not facially plausible. That's why we're here. That's why we're here. This does not help you. Ooh. You all know the saying, she who represents herself has a fool for a client. There is no bigger fool right now than Ashley Guillard. Oof. The Second Circuit noted that plaintiffs deserved, at minimum, an appropriate and reasonable opportunity to show good faith belief that the alleged damages were reasonably possible. The Second Circuit, what? You provided a citation, just you didn't name the case. Which is a change from above where she named the case, but no citation, or at least no court. But so the plaintiffs deserved at minimum, an appropriate and reasonable opportunity to show good faith belief that the alleged damages were reasonably possible. Well, here's the problem. This is from the Second Circuit in 1965. Twombly and Iqbal are from the Supreme Court in, off the top of my head, 2007 and 2009. Don't quote me on that. That's the general time frame. So before Twombly and Iqbal, this very well might have been the case, an appropriate and reasonable opportunity to show good faith belief that the alleged damages were reasonably possible. But now, what does Twombly and Iqbal say? I know I've covered this a whole lot in the past, but somehow it's side Twombly. I don't want that. So Bell Atlantic versus Twombly. Let's go to Wikipedia just because it's faster. So, well, actually, let's click Twickball. So, from Twombly, first, the tenet that a court must accept as true all of the allegations contained in a complaint is inapplicable to legal conclusions. So, legal conclusions don't work. You have to make factual allegations to survive summary, or well, to survive motion to dismiss. Second, only a complaint that states a plausible claim for relief survives a motion to dismiss. Determining whether a complaint states a plausible claim for relief will, as the Court of Appeals observed, be a context-specific task that requires the reviewing court to draw on its judicial experience and common sense. In keeping with these principles, a court considering a motion to dismiss can choose to begin by identifying pleadings that, because they are no more than conclusions, are not entitled to the assumption of truth. While legal conclusions can provide the framework of a complaint, they must be supported by factual allegations. When there are well-pleaded factual allegations, a court should assume their veracity and then determine whether they plausibly give rise to an entitlement to relief. So that's the standard you have to meet to survive a motion to dismiss now. It's not you should be given an opportunity to show good faith belief that the damages were reasonably possible. You have to bring some facts. You have to bring some facts for each and every element. Because if one of the elements of a tort isn't met, if one of the elements of a cause of action doesn't have at least some plausible fact, it's dismissed. Goodbye. Sayonara. Yeet. The end. That's all, folks. The court ordered that defendant Ashley Guillard's statements about Rebecca Scofield's role in the murders and relationship with one of the victims were clearly baseless and are likewise not facially plausible. There's our friend. Facially plausible. Facially plausible. Can't remember if that was... Facially plausible isn't in what we read, but I know I've mentioned it before. So, therefore, if statements were clearly implausible, there is no reason for the court to order that the alleged damages were reasonably possible. Therefore, there is no legal cause of action for defamation, no damages, and no award for pain and suffering. She's conflating the dismissal of her counterclaims with Professor Scofield's claims. The court said that Ashley Guillard's counterclaims were not facially plausible. That's why they were yeeted. The fact that her statements are not facially plausible, that gives rise to Professor Scofield's defamation claim, because they were untrue statements made about her that damaged her. Whether they were ridiculous or not doesn't matter. That's irrelevant. But according to Ashley Guillard, therefore, there is no legal cause of action for defamation, no damages, and no award for pain and suffering. In bad faith, the plaintiff conferred to Belcalis Marlenus Almanzir versus Latasha Transrina Kebi et al. 2022. Once again, an incomplete citation. Incomplete citation. This is the Cardi B versus Tasha K. Remember, I mentioned that in part 1. I don't know how it's bad faith to they didn't confer, they referred, they cited, they didn't confer, they didn't meet up with Cardi B and say, "Yo, bitch, how'd you get your money?" But how is it bad faith to use precedent of another social media defamation case, a high profile social media defamation case involving defamation per se, because it it involved Tasha K accusing Cardi B of having an STD and pleasuring herself with a Coke bottle, if I'm not mistaken. So that would make it defamation per se. So they found the most recent and most analogous case that has been decided in court, and they used it as a citation. How is that bad faith? That's good lawyering. It's what you're supposed to do. I mean, if you could, if Ashley Guillard could find a case that said, yeah, there's no damages, you know, pain and suffering due to defamation is impossible. If she could find that citation, would it be bad faith for her to trot that one out? She'd have it out yesterday. So, but apparently using that case in argument for the plaintiff to get $1 million for pain and suffering was bad faith. That precedent is inapplicable because it requires actual damages, reputational injury, and medical expenses. Does it? Does it? I mean, this is defamation per se. So getting to a verdict, it doesn't. It doesn't need to show damages. Showing medical expenses, if they're claiming medical injury, if they're asking for reimbursement for medical injury, for therapy expenses, whatever, then maybe you've got a point. But as I said in part one, Cardi B might not have suffered an actual reputational injury. Her music sales, her tour receipts might have improved. I mean, as far as I know, she's not irrelevant now. As you can tell, I'm a Beatles fan, not a Cardi B fan. But in her genre of music, this might have actually helped, but it's still defamation per se. Scofield's $20 for an over-the-counter melatonin does not meet the criteria established in Almanzar versus Kebby. Why don't you show us the actual holding that says these are the requirements? Huh? That would probably be a good idea, because I doubt it's there. Nor does it meet the threshold for a federal district court filing. To determine whether the amount in controversy is met, the rule is that the sum claimed by the plaintiff controls if the claim is apparently made in good faith. It must appear to a legal certainty that the claim is really for less than the jurisdictional amount to justify dismissal. And that's St. Paul Mercury Indemnity Company versus Red Cab Co. from the Supreme Court in 1938. So it must appear to a legal certainty that it's less in order for it to be dismissed for lack of jurisdiction. There is no legal certainty that it's less. Could she have suffered less than $75,000? Sure, but that's for the jury to decide, or the judge, depending on how things shake out. But at this point, that's the entire point. We don't know the exact amount of damages that Professor Scofield has suffered. But because there isn't a sum certain, there is no legal certainty that it's less. It could be colossally more than 75,000. They could be underestimating asking for $1.8 million. If this goes to a jury, it could be 10 million, 20 million. We don't know. I mean, in part one, I brought up Alex Jones. He didn't fight the first part, this part. He fought damages. So there was a default judgment as to responsibility. And this is the Sandy Hook case. Default judgment for responsibility, trial by jury as to what the damages were. It was a defamation case. What were the damages? But by Ashley Guillard standards, there were none. According to Ashley Guillard, telling 26 parents, or however many, off the top of my head, maybe the parents of, was it 20 dead kids and 6 adults in Sandy Hook? Either way, telling a couple dozen families that their dead relatives, their dead children, are just crisis actors. There's no damage there. There's no damage. This should have been thrown out on a 12B1. There was no subject matter jurisdiction because it was absolutely a legal certainty that it was less than $75,000 damage. A legal certainty. There was no contract. Alex Jones had never contracted with any of those parents. He didn't kill the kids. So the cost of burying them, that's not his fault. He caused no damages whatsoever, according to Ashley Guillard, or at least according to her logic. The jury disagreed and granted $1 billion. $1 billion. That's with a B. That's 3 commas. But according to her, it's a legal certainty that this claim is for less. That's just ridiculous. So, continuing. The court looks at the circumstances at the time the complaint is filed. Stewart versus Tupperware, First Circuit, 2004. She's really, really heavy with the persuasive citations. She does not venture into the Ninth Circuit very often. I wonder why. At the time of the complaint and a post-complaint, Plaintiff Rebecca Scofield did not suffer any damages. The purchase of a $20 sleep aid does not amount to the required $75,000 in damages for jurisdiction under 28 U.S.C. Section 1332. Thus, the complaint must be dismissed for lack of subject matter jurisdiction. So, this section was supposed to be that the order dismissing the counterclaims is void. Her prayer for relief at the end of this section is dismiss the complaints. Those are not the same thing. But carrying on, the next section, the court does not have personal jurisdiction over Ashley Guillard. Venue is improper. At the commencement of the filing of the complaint, Ashley Guillard was a Houston resident residing in Houston. Plaintiff Rebecca Scofield, through attorney Wendy Olson, served Ashley Guillard at her home. The plaintiff falsely claimed that the venue is appropriate under 28 U.S.C. section 1391 because Professor Scofield is an Idaho resident and a substantial part of the events giving rise to the claims occurred in Idaho. The plaintiff contradicted herself. She claims that she did not order the murder of the 4 University of Idaho students who were killed on November 13th, 2022. Yet, she claims that her civil complaint is a result of the event of the murders. Since Rebecca Scofield claims to not have killed the students, the only event that gave rise to the civil action is the alleged defamation that occurred on social media, published mostly in Texas and accessed in several states. The problem is, the TikTok videos made allegations about the murders which occurred in Idaho. So the truth or falsity of the defamatory statements, which were made in Texas, yes, the defamatory statements were made in Texas, but the evidence about their truth or falsity is in Idaho, whether Professor Scofield has any involvement or not. The witnesses are all in Idaho. The victims are all in Idaho. The law enforcement investigating it is all in Idaho. If they have to call any of these people as witnesses in this case, they're not going to be able to drag them down to Texas. A witness doesn't have to travel cross country on a subpoena. They can volunteer to, they can agree to, they can make you pay for their travel expenses. So if all of the witnesses are in Idaho, the case should probably be in Idaho. Pursuant to 28 U.S. Code, Section 1391b1 and 28 U.S.C. 1391b3, the proper venue would have been Federal District Court for the Southern District of Texas, except the plaintiff does not have damages exceeding $75,000. But that doesn't matter for personal jurisdiction. That doesn't matter. That's completely irrelevant in this section. You're no longer arguing subject matter jurisdiction. You're no longer arguing subject matter jurisdiction. Don't even bring it up in this section. But once again, this is a mere conclusory statement. It's her argument. That doesn't mean it's the truth. I mean, she thinks, I'm working this out, she thinks this is a complete get out of jail free card. Well, if she wanted to sue me, she should have sued me in the Southern District of Texas, but she couldn't have even done that because she didn't have diversity jurisdiction, so she's out of luck. Well, then she would have sued you in Texas State Court because it doesn't have the $75,000. Well, it's not diversity jurisdiction. It's just the general civil jurisdiction of Texas state courts. So this is just for federal court. But she's going to think, because remember in her counter complaint, she sued under section 4001. I can't remember which title it's under, but basically she sued under the definition of defamation from the statute for enforcing foreign defamation verdicts, foreign judgments in federal court. So because the reason it has to have diversity jurisdiction is because it's a state law, common law tort. There is no statute. It's common law, state level common law. But she thinks, well, go to the federal law. That's where I found it in federal law, was section 4001. And that federal law there, it says in order to sue for defamation, there's got to be at least $75,000 in damages. So if you can't show that right at the outset, you can't even sue me. Except she can, because there's still state court. But once again, if Professor Scofield hasn't been damaged by $75,000, like if it's conclusive at this stage that there is no damage whatsoever, maybe $20 total. What damages has Ashley Guillard suffered to countersue? None. Well, definitely none, because she hasn't been defamed, at least not that I know of, certainly not by Professor Scofield. So, thus, jurisdiction is improper, and so is the venue. Pursuant to 28 U.S. Code Section 1406A, the district court of a district in which is filed a case laying venue in the wrong division or district shall dismiss, or, if it be in the interest of justice, transfer such case to any district or division in which it would or could have been brought, for as long as the objection to the venue is interposed timely and sufficiently. Timely and sufficiently. Remember yesterday, motion to dismiss for improper venue, 12B3. And I said yesterday, I meant part 1, which I recorded yesterday, but you're getting within an hour of each other. In order to bring a 12B3 motion, it must be asserted before a responsive pleading, if a responsive pleading is allowed. So it must be brought before you answer. This is months after she answered the complaint. Thus, it is not timely. It's so far from timely that it's laughable. By objecting to the venue in her answer and counterclaims, defendant Ashley Guillard met the time and sufficient objection requirements of 28 U.S. Code Section 1406B. Additionally, a void judgment may be attacked at any time by a person whose rights are affected. See Alcara versus Texas Alcoholic Beverage Commission, still with the Texas Court of Appeals. That's state court. That's not good law for Idaho federal court. Neither is Evans versus C. Woods. So, as the court ordered in docket 49, when venue is improper, the case must be dismissed or transferred under 28 U.S.C. Section 1406A. Do we need to take a look at docket 49? Okay, well, 1406 is what we're after. Okay, so this is a footnote. When venue is improper, the case must be dismissed or transferred. But see 1406b, nothing in this chapter shall impair the jurisdiction of a district court of any matter involving a party who does not interpose timely and sufficient objection to venue. Okay. Defendant could have challenged plaintiff's complaint for improper venue in accordance with Rule 12b3. I mean, there's... Let's see. Okay. So this is discussing her 1985 claim, which was patently ridiculous. So basically, the court said in the order, rather than bring a 1985 claim, because her 1985 claim was, they're discriminating against me by suing me in the wrong venue. And the court says, rather than bringing a 1985 claim, the defendant could have challenged for improper venue. It's not saying that it is the improper venue. It's saying you could have challenged venue, but you didn't, at least not properly. Besides which, you consented to the venue by countersuing. That's a waiver. That's a waiver of personal jurisdiction and wrong venue claims. So it's just, it's ridiculous. It's ridiculous. Let's move on. So next up, the order and entire complaint is void due to a lack of judicial impartiality pursuant to Rule 60b-6. Judicial impartiality. Wow. Judge, you are in cahoots with Professor Scofield. The only way you're not in cahoots with the other party is by ruling in my favor all the time. It doesn't matter that my arguments are wrong and frivolous. You've got to agree with me. Otherwise, you're showing favoritism. Just because her arguments are right and based on law and fact doesn't mean you have to agree with her. Fairness would be, eeny, meeny, miny, mo, or one for you, one for me. In Ashley Guillard's answer, affirmative defenses and counterclaims, she promulgated Did she have a thesaurus write this? She didn't promulgate anything. What? But she promulgated that the complaint was filed in federal district court for the District of Idaho for the purpose of impeding upon judicial fairness and impartiality for her. The court in docket 49 proved her allegation to be true. The order is obviously biased, one-sided, lacks in impartiality, and likely maliciously motivated. Wow. Wow. And you didn't promulgate. You pontificated, you postulated, you didn't promulgate. First, the court violated the First Amendment of the United States Constitution by ruling on the plausibility of Ashley Guillard's tarot reading and psychic abilities. The court, under the tutelage of Chief U.S. Magistrate Judge Raymond E. Patrico, called Ashley Guillard's spiritual practice arguably so outrageous as to be clearly baseless and thus implausible and lack any basis in fact. No, he didn't call your spiritual practice. He called your claims about Professor Scofield outrageous, clearly baseless, and implausible, and lacking any basis in fact. There's a difference. You may believe them, but it's outrageous of you to say it. It's a reckless disregard for the truth. The first two provisions of the First Amendment, known as the religion clauses, state that Congress shall make no law respecting or disrespecting an establishment of religion or prohibiting the free exercise thereof. Federal law restricts the ability of the government, including courts, to judge the legitimacy of religious beliefs. See U.S. versus Seeger, Supreme Court 1965, U.S. versus Ballard, Supreme Court 1944. Amendment 1. Amendment 1.4.2. Laws regulating religious belief. So the problem is he's not regulating your religion. He's not regulating your religion. You can play with your tarot cards to your heart's content. He hasn't told you you can't. You just can't accuse people of murder baselessly. That's defamation. That's a generally applicable law. Your religion isn't a get out of jail free card. Well, Your Honor, you can't violate my religion. My religion says I've got to murder those so-and-sos. No. It's not saying anyone is allowed to murder unless you belong to this religion. It's a generally applicable law. Same with drug laws, with very limited exceptions for Native Americans. If a drug is illegal, you're not going to be able to use it for your religious practices. I mean, Rastafarians, weed's illegal federally. Sorry. I don't necessarily agree with it, but it is. And it's generally applicable. It doesn't say no weed unless you're Rastafarian, no weed unless you're, Pastafarian. So the test of religious belief within the meaning of the exemption in Section 6J is whether it is a sincere and meaningful belief occupying in the life of its possessor. To disqualify the discrimination of Ashley Guillard's spiritual beliefs and practices as class-based animus, Chief U.S. Magistrate Judge Raymond E. Patrico falsely claimed it as a philosophy without any evidence suggesting so, and with all the dockets at least 100 times suggesting that it is her spiritual belief and practice. But once again, it doesn't matter. It's your statements that matter. It's your statements that matter. Like I said, if I go out and murder someone because I believe that, here in Utah, a distant relative of mine, we have pioneer era ancestors, so, you know, and but what's his name? What's his name? Hmm. I think I know it. I think I know it. Cleon Skousen. So basically his pioneer era ancestor settled here in Utah, but when the Mormon church banned polygamy, he moved to Mexico along with the Romneys and a few others, whereas my ancestor stayed in Utah. And so 40, 50 years ago, Cleon Skousen declared that there needed to be a blood atonement. And so he had a hit list of people that needed to be killed, most of them relatives of his, I believe. This was his religious belief. It was, God told me that these people need to be killed. It was his sincere religious belief. Or maybe his just supreme narcissism. But either way, he still was a murderer, or at least conspired to murder people. There's still people in hiding. He's been dead for 40 years. There are still people in hiding. They're so scared of him because his followers were that fanatical. If that's not religion, what is? I mean, it's definitely on the cultier side of religion, but it's religion. So if these guys can go to jail for murder, go to prison for murder for their sincere religious beliefs, because once again, it's not the practice of their religion, it's the murder, it's the killing because of their religious belief. It's illegal. It's generally applicable. It's not your religious belief. It's not your playing with your tarot cards. It's your 100 TikTok videos calling someone a murderer. It's generally applicable. It's a generally applicable law. You can't defame people. Yet, the same statements are then used to justify the plaintiff's complaint and are suddenly statements of fact. It doesn't mean that they are true. You made them as statements of fact. You made them statements of fact. They were not statements of opinion. That's the difference. He's not asserting the truth of them. Patrico conveniently changes his viewpoint when it is convenient for Scofield and her legal counsel. Additionally, Patrico assumes that Rebecca Scofield, without any evidence or proof, did not cause the murder of the 4 University of Idaho students. That's because, now I know this is a difficult concept, but your conclusory facts are not proof. There has been no evidence or proof that she murdered the students. No proof. None. None. Professor Scofield saying, I did not murder these students. Hey, that's proof. You may not like it as proof. You may disagree with it, but she's a firsthand witness to her not murdering anyone. It's hard to prove a negative. But Professor Scofield, she has herself as a witness to never committing any murders, but she also has evidence that someone else was arrested. That's proof. You saying this person I have never met that I picked out of the blue looking at the university website is the murderer, that's not proof. That's just a conclusory statement. The murder investigation is not within the judge's control or jurisdiction. He does not know for a fact, nor does he have evidence that Rebecca Scofield did not order the murder of the 4 University of Idaho students. Therefore, he cannot decide on the plausibility of the message of Ashley Guillard's tarot reading. Patrico overstepped his authority. He does not have subject matter jurisdiction over the case murder of the 4 University of Idaho students, which is being handled by the state of Idaho Judicial Branch, Latah County District Court, case number that. Nor does the courts have jurisdiction over the plausibility of tarot readings, which is a spiritual practice. Third, in the same order, Chief U.S. Magistrate Judge Raymond E. Patrico lightly promised sanctions in the future, stating, with this in mind, the court's current refusal to assess sanctions against defendant does not foreclose on the possibility that sanctions may be appropriate later. Sanctions against Ashley Guillard were never appropriate, and there was no indication or evidence that sanctions were to be appropriate in the future. Patrico is inappropriately biased, and his behavior impedes upon due process for Ashley Guillard. But the sanctions were for bringing outrageous counterclaims. I mean, 1985 was outrageous. 4001, suing over a definition, outrageous. Having absolutely no facts or evidence, outrageous. Having nothing but conclusory statements, outrageous. Missing every deadline possible, outrageous. Lastly, after the order, Chief U.S. Magistrate Judge Raymond E. Patrico ordered a subordinate to email the parties seeking settlement negotiations after the filing of his biased order. Without the opportunity for discovery and due process, the court suggested that defendant Ashley Guillard concede again, unconstitutionally assuming that the statements made about Scofield are false. This is after the parties established that alternative dispute resolution is not useful in this case. So, he ordered a subordinate to email the parties seeking settlement negotiations. That's not bias. He's trying to, if you can reach a settlement might be in your favor. Settlement might be in your favor. But if settlement's impossible, it's the rules are there's a settlement conference in the rules. That settlement conference might be you both show up, tell each other to eat shit, and leave. That might be the extent of the settlement conference because you're that far apart. But it's still in the rules, so the judge is going to tell you, hey, try to settle. That's not bias, that's judicial economy. But next up, order docket 49 is void because the court, Federal District Court for the District of Idaho, does not have subject matter jurisdiction over the plausibility of spiritual practices. Luckily enough, that's not what it's ruling on. It has jurisdiction over defamation claims under diversity jurisdiction. That's what it's discussing. This is like delete laws saying he was arrested for filming the cops. He wasn't. He was arrested for interfering, for obstruction. He was obstructing by, he was filming while obstructing, but he wasn't arrested for filming. If he would have followed the directions to move back and stop speaking with the detainee, he wouldn't have been arrested. He could have kept filming. Here, she's not being sued for her tarot reading. She's not being sued for her spiritual practices or the plausibility thereof. She's being sued for defamation. And I need to speed this up because it's so ridiculous that I can't help but comment, but I need to speed it up. Federal law restricts the ability of the government, including courts, to judge the legitimacy of religious beliefs. See U.S. versus Seeger, Supreme Court, 1965. U.S. versus Ballard, Supreme Court, 1944. Amendment 1.4.2, laws regulating religious belief. So, same citations from above. The test of religious belief within the meaning of exemption in Section 6J is whether it is a sincere and meaningful belief occupying in the life of its possessor. In all relevant dockets, Ashley Guillard has vehemently defended her spiritual beliefs and spiritual practice, to include tarot readings, her psychic abilities, and spiritual connection. In all relevant dockets and the hearing, Ashley Guillard continued to defend her beliefs. Judge Raymond E. Patrico had no evidence to suggest that Ashley Guillard's spiritual practices were secular or philosophical. The court intentionally erred in denouncing tarot readings and Ashley Guillard's spiritual connection as a spiritual practice for the purpose of overstepping the separation of the church and state as required by federal laws and the First Amendment of the U.S. Constitution. So once again, I know I'm a broken record by this point. And I don't see how we're on page 13 of 30 and at the conclusion. Unless she must have, well, it must be an exhibit. So either way, I thought this was going to take a whole lot longer, assuming the exhibit is the attachment of the order. But once again, the validity of her spiritual practice, of her tarot reading, of her psychic abilities are irrelevant. The question is, was it false for her to claim that Professor Scofield murdered 4 students? And if it was false, was it reckless for her? Well, if she believed. So the question isn't, Did she believe it or not? It's not the standard isn't whether or not you believe what you say. Let's put it that way. So I can't say, Your Honor, I 100% believe that this person is the murderer. If that belief is reckless. It's if I have a reckless disregard for the truth, if I close my eyes to the evidence to the contrary. So the question here is, did Ashley Guillard have a reckless disregard for the truth by relying on tarot cards to make 100 TikTok videos calling someone a murderer? That's the question. That's the issue, not whether she is a psychic. The court doesn't have to decide that. Just whether her statements were true and whether she had a reckless disregard for the truth in asserting it. That's it. That's it. That's it. All her caterwauling to the contrary, this is the standard. So, conclusion. Judgment is a void judgment if court that rendered judgment lacks jurisdiction of the subject matter or of the parties, or acted in a manner inconsistent with due process. Margulies versus John. Hey, we're going to the Seventh Circuit this time. 1981, cert denied. Clue versus United States. That's one we saw in part 1 from the F-Suit. And like I said, I don't know if that's District of South Carolina or whatever. Federal Rules of Civil Procedure, Rule 60B4 and 28 USC something. A court cannot confer jurisdiction where none existed and cannot make a void proceeding valid. FRCP Rule 60B4 provides that the court may relieve a party from a final judgment or order, and relief may be granted for circumstances under which a judgment is void. Courts are constituted by authority, and they cannot go beyond that power delegated to them. If they act beyond that authority, and certainly in contravention of it, their judgments and orders are regarded as nullities. They are not voidable, but simply void. And this even prior to reversal. William V. Berry. Oh, hey, we're going back to 1850. And I don't know what court that's out of because she doesn't tell me. A party affected by void judicial action need not appeal pursuant to state ex rel lati. Another incomplete citation. A void order can be challenged in any court. Old Wayne Mutual Loan Association versus McDonough. Hey, Supreme Court, 1907. It is not necessary to take any steps to have a void judgment reversed, vacated, or set aside. It may be impeached in any direct action or collateral. Holder versus Scott. Texas Civil Appeals Court, Texarkana, 1965. So that's irrelevant. This is just a string of citations in the conclusion. Put them in your argument. Put them above the conclusion. Jesus. In Griffin versus Griffin, Supreme Court in some year, a pro se litigant won his case in the Supreme Court who stated, a void judgment is a nullity from the beginning and is attended by none of the consequences of a valid judgment. It is entitled to no respect whatsoever because it does not affect, impair, or create legal rights. Ex parte Seidel, Texas Criminal Appeals Court, 2001. Ex parte Spalding, probably Texas, Southwestern Reporter, I know I should give her a break. She is pro se. Citing your sources in legal work is difficult, but when she has a pick and mix of jurisdictions she's working with, it's really annoying. Really annoying. Thus, the court must void the order, docket 49. Additionally, the court must dismiss the complaint due to a lack of jurisdiction of the subject matter of the parties and due to the impediment of due process for defendant Ashley Guillard. But once again, if the court lacks jurisdiction, what does it matter reversing docket order 49? You want your claims reinstated in Idaho, but not the others. But why? Unless you just want to undo the dismissed with prejudice part. If you want to yeet the with prejudice. So, dismiss the complaint, docket 1, with prejudice. Pursuant to 28 U.S. Code Section 1406A, the district court of a district in which is filed a case laying venue in the wrong division or district shall dismiss, or if it be in the interest of justice, transfer such case to any district or division in which it would or could have been brought. It is not in the best interest of justice to transfer the complaint to any court because it is not a valid cause of action. Pursuant to the court in docket 49, the judicial privilege immunizes a party from civil liability for statements made during judicial proceedings. See Berrien versus Berberian, Idaho 2020. Idaho has long recognized that defamatory statements made during a judicial proceeding are absolutely privileged, even if made with malicious intent or knowledge of their falsity. The purpose of the judicial privilege is to keep the paths leading to the ascertainment of truth as free and unobstructed as possible. This privilege sets a low bar, requiring only that the defamatory statements be made during a proceeding, and 2, have a reasonable relation to the cause of action of that proceeding. Dickinson Frozen Foods, Inc. versus J.R. Simplot, Idaho 2019. I just can't. I can't. So remember in part 1 when I mentioned how I had only very briefly glanced at her opposition to the summary judgment motion. This is the argument I saw. It wasn't for dismissal of her claims, but for opposing the summary judgment. She's trying to say, I haven't made it that far yet here, but she's trying to say, hey, Professor Scofield has argued for the litigation privilege, saying that I can't sue her because of the litigation privilege because the things that she said are during the course of litigation. Well, that means she can't sue me either because everything I said is during the course of pending litigation because the state is criminally prosecuting Brian Koberger. That's litigation on the same set of facts, or at least some of the same set of facts. Therefore, even though I'm not a party to that litigation, Professor Scofield isn't a party to that litigation, it shields me. And that might just be her dumbest argument yet. But once again, that would bar her from it's dumb. It's dumb. I really dislike her. So, defendant Ashley Guillard's statements about Rebecca Scofield's alleged involvement in the murder of the 4 University of Idaho students were made during judicial proceedings, specifically during the investigation of the murders. Although Ashley Guillard is not a party in the criminal case, she sent her findings to the FBI tip line as a witness to help solve the case. Therein, her statements easily meet the standard of judicial privilege, and the plaintiff fails to state a defamation claim. Additionally, pursuant to Berrien versus Berberian, statements to law enforcement for the purpose of initiating criminal proceedings are entitled to a qualified privilege for all torts except malicious prosecution. Therefore, the defendant Ashley Guillard's statements on social media are also privileged due to the reasonable relation to the pending criminal case of the murder of the 4 University of Idaho students, pursuant to Berrien versus Berberian. Additionally, Rebecca Scofield has not proven that the statement that she ordered the murder of the 4 University of Idaho students to hide the relationship she had with one of her victims is false. Thus, the complaint fails to state a claim for relief and must fail, and it is in the interest of justice to dismiss the complaint in lieu of a transfer. Gah! You don't prove things in a complaint. You allege things in a complaint. As Emily Baker says, Emily D. Baker, lawsuits are shade and allegations. Allegations and shade. Nothing is proven until you put evidence before the court. Evidence. The complaint is not evidence. It's allegations. She has alleged that she has not murdered anyone. She has alleged that she has not contracted anyone to commit murders for her. She has alleged that the statements are false. Those are allegations. Taking those allegations as true, because remember, for the purposes of a motion to dismiss, you take the allegations as true for the purposes of the motion to dismiss. You say, if these allegations are true, is there enough to sustain such a cause of action? So, by the very rules of litigation, Professor Scofield not proving anything yet is completely irrelevant because she can't prove anything yet. She doesn't have to prove anything yet. She only has to make allegations, plausible allegations that, if taken as true, could sustain the cause of action. Ashley Guillard not agreeing doesn't mean anything. And Professor Scofield herself can make these allegations. She can say, just pisses me off. And as to the qualified privilege, the litigation privilege. So you'll notice, let's see. So although Ashley Guillard is not a party in the criminal case, she sent her findings to the FBI tip line as a witness to help solve the case. Do you know what defamation claim Professor Scofield hasn't brought? The FBI tip line. She sued you over the TikToks, not over the FBI tip line. That may be evidence. That may be evidence she can use. but she didn't sue you over it. So whether that's privileged or not is irrelevant because that's not been alleged. It's irrelevant. And your TikToks were not to the FBI tip line. They were public. You can't try to insert yourself as a witness into a criminal investigation in order to defame someone with impunity. I can't, Sam Bankman-Fried was found guilty of all charges in the SDNY earlier today. Well, I guess yesterday because it's after midnight, but either way, he was just found guilty. I couldn't call the FBI white-collar tip line during the SBF investigation and say, so, yeah, Elon Musk is best friends with SBF, and SBF did all of this at Elon Musk's bidding, so you should charge him with conspiracy to commit securities fraud. And then go and make 100 TikTok videos saying, yeah, Elon Musk, he's committed securities fraud all over the place. Didn't you know that? And when Elon inevitably sues me, I can't say, well, I made a call to the FBI tip line about the SBF trial saying you're really the mastermind. That wouldn't insulate me from liability. That's preposterous. So, prayer for relief. 1. Rule 12b1, dismiss the action due to lack of subject matter jurisdiction. 2. Dismiss the action due to lack of personal jurisdiction pursuant to Rule 12b2. 3. Dismiss the action with prejudice due to failure to state a claim for relief pursuant to Rule 12b6. 4. Set aside docket 49 pursuant to Rule 60b4 and 60b6. 5. Award Ashley Guillard all court-related fees and sanctions pursuant to Rule 11C in the amount of $1 million pursuant to B. Chambers versus NASCO. I can't even with it. I mean, footnote 1. Sanctions totaling nearly $1 million were upheld by the Supreme Court for the petitioner's 1. Attempt to manipulate the court of jurisdiction by acts of fraud. 2. Filing false and frivolous pleadings. And 3. Attempting by other tactics of delay, oppression, harassment, and massive expense to reduce the respondent to exhausted compliance. But that $1 million would have some relation to the attorney's fees that the party had to spend. You're pro se. You haven't shown expenses. Jeez. And Exhibit A. Oh, it's the GoFundMe. Speaking of which, please support Professor Scofield's GoFundMe. I've had it in the description of every one of my YouTube videos for several months because I think you should support Professor Scofield in her attempt to receive justice. That was what is known in the industry as a hot mess. But now let's take a look at Professor Scofield's memorandum in opposition to defendant's motion to set aside and motion to dismiss. And what do you bet? The very first argument is this is untimely because Rule 12b says, as we've looked multiple times, still highlighted, A motion asserting any of these defenses must be made before pleading if a responsive pleading is allowed. That sentence is going, I haven't read Professor Scofield's opposition brief at all. That sentence is going to be in there. Table of contents. Whoa! Guillard's arguments under Federal Rule of Civil Procedure 12b are untimely. I know I scrolled down to the table of contents, but I swear I didn't see that. I didn't look at it before switching over to the rule and telling you that would be their first argument. But it's their first argument. But B, if the court looks past Guillard's untimeliness under Rule 12b, her motion to dismiss still fails because 1, the court has subject matter jurisdiction. 2, Guillard has waived or forfeited any challenge to personal jurisdiction. Why? Because she countersued. That's consenting to personal jurisdiction. 3, on the merits, the court has personal jurisdiction because she has availed herself of the state of Idaho. Idaho has long-arm jurisdiction. 4, Professor Scofield selected the proper venue. And 5, Professor Scofield has stated a claim for defamation. And then C, Guillard cannot seek relief under Rule 60b because the court has not entered a final judgment or order. I know we looked at 60b in the part 1, but grounds for relief from a final judgment or order or proceeding on motion and just terms, the court may relieve a party of it or its legal representative from a final judgment, order, or proceeding for the following reasons. So I think she did B4, so the judgment is void, or 6, any other reason that justifies relief. I mean, the litigation is still ongoing, but, well, the problem here is, Guillard has argued that docket 49, the order, needs to be reversed. Docket 49, to me, is a final judgment. It is a final judgment. It dismissed the counterclaims with prejudice. That's a final judgment. The problem is, her argument is that it needs to be set aside, it needs to be reversed in order to dismiss Professor Scofield's claims because the judgment is void. But there is no final judgment on Professor Scofield's claims, so Rule 60b doesn't apply to any of Professor Scofield's claims. So any argument about setting aside the final judgment on docket 49 due to Rule 60b 4 and 6, that would only be to reinstate the counterclaims. It would have absolutely nothing to do with dismissing Professor Scofield's claims. The problem is, she didn't argue that her claims need to be reinstated, that the counterclaims need to be reinstated. She tried to do 1 + 1 = elephant. It wasn't, you need to set aside this final judgment because it is void for these reasons. Therefore, my counterclaims need to be reinstated. So I'm interested to read that section just because, you know, she's right. It requires a final order or judgment. But what's Guillard arguing for is the problem. Then next up, D. Guillard's arguments to set aside the dismissal of her counterclaims fail on the merits. E. The court should award Professor Scofield her attorney's fees. At some point, the court really does need to, and it could at the end of all of this. The court not awarding attorney's fees at the end, at the conclusion, when it rules on certain motions, doesn't mean attorney's fees aren't going to be considered. Professor Scofield may very well be awarded her entire attorney's fees upon final judgment. And by right, she should be awarded attorney's fees. Which doesn't mean you shouldn't support her GoFundMe, because it's been a while since I've stated this. I have communicated with Professor Scofield. The GoFundMe goes to attorney's fees. Any extra will go into the University of Idaho Scholarship Fund in the name of the 4 murder victims. So either way, it's a good cause. So then the conclusion. So, introduction. Until now, defendant Ashley Guillard has been happy to use this court as a platform to inflict unnecessary delay and expense on plaintiff Rebecca Scofield. She litigated her default here, filed and litigated counterclaims here, tried to drag plaintiff's counsel into the litigation here, participated in a discovery conference here, and issued an overbroad subpoena to Facebook here. Professor Scofield has incurred great expense to beat back those often frivolous efforts. With the court's decision on August 8th, 2023, ECF 49, Professor Scofield seemed to be finally past Guillard's roadblocks and could focus on moving forward with what is really at issue, her defamation claims against Guillard. But Guillard refuses to stop with the expensive distractions. Unhappy with how the litigation is going, she has pivoted to attacking the court, wrongly accusing the court of bias and seeking to void all her losses to date so that she can try again elsewhere. Guillard's assertions are too late, but also fail legally. The court should deny Guillard's motion. Argument. Guillard's arguments are not always linear, but as best Professor Scofield can tell, Guillard seeks to 1. Dismiss Professor Scofield's complaint for lack of subject matter jurisdiction because the amount in controversy does not exceed $75,000. 2. Dismiss Professor Scofield's complaint for improper venue because Guillard lives in Texas. 3. Dismiss Professor Scofield's complaint for lack of personal jurisdiction because Guillard lives in Texas. 4. Dismiss Professor Scofield's complaint because it fails to state a claim. And 5. Set aside the court's order dismissing Guillard's counterclaims because the judicial officer assigned to this case is biased and the court lacks jurisdiction. Guillard's first 4 arguments are untimely, and all 5 arguments fail legally. And besides which, if the judicial officer is biased, request their recusal. Say, yo, judge, give me another judge. That's the process. it's not a reason to dismiss a case, especially not with prejudice. And the opening line here, Guillard's arguments are not always linear, but as best Professor Scofield can tell. That's a nicer way of saying what I said when I said, as far as I can tell, her argument is 1 + 1 = elephant. Except, no, sorry. It's not 1 + 1 = elephant. Because that would be her proof is fine and her conclusion is wrong. So this is 1 + Studebaker = elephant. That's closer to what her argument resembles, if you broke it down to a mathematical equation. 1 + Studebaker = elephant. If anyone is able to mathematically prove that, I'll be impressed. So, A, Guillard's arguments under Federal Rule of Civil Procedure 12b are untimely. Guillard moves for dismissal under Federal Rule of Civil Procedure 12b-1, 2, and 6. ECF 50-1. I think it was more than 1, 2, and 6. Because 1, 2. Oh, sorry. I was on Rule 60. 1, 2, 3, and 6. Can't forget 3, venue. Either way, a motion asserting any of the defenses available under Rule 12b must be made before pleading if a responsive pleading is allowed. Remember when I guaranteed that would show up in her argument? Wow. It's almost like that's the rule. And that's Federal Rule of Civil Procedure 12b. And with emphasis added, before pleading, if a responsive pleading is allowed. Emphasis on before pleading. A responsive pleading includes an answer being, by its very name, responsive. Federal Rule of Civil Procedure 7A2. Let's take a look at that. So, Title 3 in the rules, pleadings and motions. Rule 7, pleadings allowed, form of motions, and other papers. Pleadings, only these pleadings are allowed. A complaint, an answer to a complaint, an answer to a counterclaim designated as a counterclaim, an answer to a cross-claim, a third-party complaint, an answer to a third-party complaint, and, if the court orders one, a reply to an answer. Motions and other papers. So 7A2, an answer to a complaint. I mean, that doesn't specifically say that that's a responsive pleading, just that that's one of the pleadings allowed. But either way, it's a responsive pleading. Guillard has twice filed an answer, ECF 6 and ECF 20. Her motion under Rule 12b is thus untimely and should be denied. If I'm not mistaken, she's answered 3 times. 1 while she was in default, so it didn't count. 1 was too long, so it didn't count. And then finally, ECF 20 is the operative answer. So, but if the court looks past Guillard's untimeliness under Rule 12b, her motion to dismiss still fails. If the court allows Guillard to assert an untimely Rule 12b motion or seek similar relief under a different rule, her arguments still fail. The court has subject matter jurisdiction under 28 U.S.C. 1332a1 because there is a diversity of citizenship between the parties and the amount in controversy is greater than $75,000. Guillard has waived or forfeited any challenges to the court's personal jurisdiction by failing to assert those defenses in her answer and consenting to the court's personal jurisdiction through her conduct during this litigation. In any event, Guillard's challenge to the court's personal jurisdiction fails on the merits. Although Guillard has, at times, asserted that Professor Scofield filed in the wrong venue and failed to state a claim, those arguments also fail on the merits. Professor Scofield's venue selection is proper because she was injured in Idaho. She has also stated a claim by asserting that Guillard made false statements about Professor Scofield that were defamatory and caused injury. So we'll take each of those in turn. 1. The court has subject matter jurisdiction. Professor Scofield invoked the court's diversity jurisdiction under 28 U.S.C. section 1332. Diversity jurisdiction is proper when the parties are citizens of different states and the amount in controversy exceeds $75,000. And just for fun, let's go U.S. Constitution, Article 3. This is for those of you who haven't watched my video debunking that sovereign citizen who claims there's only two jurisdictions allowed in court, maritime admiralty jurisdiction or common law jurisdiction. Well, this would be a common law claim anyway, so by his logic, there is jurisdiction, but either way. Okay, I don't like this one that I clicked on, so let's go here, because this is the one I used. So, the judicial power of the United States shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, blah, blah, blah. Here's the one. To controversies between citizens of different states. So there is diversity jurisdiction right there in the Constitution. So you should still watch that video because it's a common sovereign citizen claim about jurisdiction, and I very thoroughly debunked it. So Guillard does not contest that the parties are citizens of different states, Texas and Idaho, but she appears to argue that the amount in controversy does not exceed $75,000 because she does not believe that Professor Scofield was damaged by Guillard repeatedly stating that Professor Scofield had an affair with a student and ordered the murder of 4 students. When a plaintiff originally files in federal court, the court determines the amount in controversy from the face of the pleadings. And that's from Geographic Expeditions, Inc. versus Estate of Lotka, ex-rel Lotka, 9th Circuit, 2010. Hey, we're actually getting good authority here, not persuasive authority, because, real lawyers. The plaintiff's alleged amount in controversy controls so long as the claim is made in good faith. When a defendant challenges the plaintiff's alleged amount in controversy, courts in the 9th Circuit use the legal certainty test to determine whether the complaint meets Section 1332's amount in controversy requirement. That's Naff versus Frey, 9th Circuit, 2015. Under the legal certainty test, A federal court has subject matter jurisdiction unless, upon the face of the complaint, it is obvious that the suit cannot involve the necessary amount. That's from Geographic Expeditions again. So, once again, if the amount in controversy, if there's a sum certain, like if it's a breach of contract and the contract is for $25,000, $25,000 is always less than $75,000. So on its face, the amount in controversy cannot satisfy the diversity of citizenship the diversity jurisdiction requirements, the amount in controversy requirement. So on its face, it's not enough. But if the court has to figure out an amount, then on its face, you don't know what it is yet. So as long as you're claiming it in good faith, it's good enough for now. Applying the legal certainty test here, plaintiff has properly invoked the court's diversity jurisdiction. Guillard admits to posting over 100 TikTok videos stating that Professor Scofield had an affair with a student and ordered the murders of 4 students. As the court knows, Guillard has continued to make those statements during hearings and in her filings. It should go without saying that accusing an educator of having an improper affair with a student and ordering the murder of 4 students, 1, places the educator's job in jeopardy, 2, deters students from wanting to take classes with the educator or taught by the educator. I don't know, maybe if you know the teacher's going to sleep with a student, it might encourage you to take classes from her. Of course, unless you really dislike yourself, you're not going to take classes from someone who murders their students. So, 3, deters publishers and co-authors from wanting to work with the educator. 4, deters individuals from attending the educator's presentations. And 5, causes the educator extreme emotional distress as the many years dedicated to their education and professional reputation goes down the drain. In the internet era, a person's reputation is often dictated by Google's results when searching their name. During the height of Guillard's war against Professor Scofield's reputation, particularly before TikTok apparently removed her accounts, a person Googling Professor Scofield typically learned about Guillard's statements about her and nothing else. And this all occurred before Brian Kohberger was arrested. It can be difficult to remember now that the public's focus is on Kohberger's trial, but when Professor Scofield filed her complaint, the public had little, if any, information about the murders at the University of Idaho. Many people in Idaho were traumatized by the murders and terrified that the murderer was unknown and at large. And this is a good point. The damage, like, if after your reputation was damaged, you're able to rehabilitate it, or if some other things have happened to rehabilitate your image, that doesn't mean it wasn't damaged at the time. So you have to take this from the perspective of when the TikToks were made. We didn't know who the murderer was at the time. So in November of 2023, it's ridiculous. It's ridiculous to say Professor Scofield's the murderer. And we know it's ridiculous. But in November of 2022, some people took it seriously because we didn't know yet. So that's the damage standard that you've got to look at it by. That's not to say, of course, that Ashley Guillard's continued defamation, if she continues with the defamation, once the case is over, even though we know it's patently ridiculous, that doesn't foreclose on the opportunity of Professor Scofield suing again. And as we discussed in part A, due to claim preclusion, it's just that much easier for her to sue again because the court has already concluded that calling her a murderer for this reason is defamation. So the public, especially those active on the internet, obsessed over the smallest details or leads in quotation marks, with many convinced that missed phone calls meant an ex-boyfriend was responsible, or that video footage meant a man wearing a hooded sweatshirt near a food truck was to blame. That was the environment when Guillard made many of her statements about Professor Scofield. And the statements made in that environment put her life, her career, and her mental health in peril. The value of Professor Scofield's life, career, and mental health far exceeds $75,000. She properly invoked the court's diversity jurisdiction. Next up, Guillard has waived or forfeited any challenge to personal jurisdiction. Unlike challenges to the court's subject matter jurisdiction, challenges to the court's personal jurisdiction can be waived or forfeited. A party waives a challenge to the court exercising personal jurisdiction by failing to include it in a responsive pleading. Federal Rule of Civil Procedure 12H1B2. Let's take a look at that. Waiving and preserving certain defenses. When some are waived, a party waives any defense listed in Rule 12B 2 through 5 by omitting a motion in the circumstances described in Rule 12G2, or failing to either make it by motion under this rule or include it in a responsive pleading or in an amendment allowed by Rule 15A1 as a matter of course. When to raise others. Failure to state a claim upon which relief can be granted, to join a person required by Rule 19B, or to state a legal defense to a claim may be raised in any pleading allowed or ordered under Rule 7A by a motion under Rule 12C or at trial. And then lack of subject matter jurisdiction. If the court determines at any time that a lack of subject matter jurisdiction, the court must dismiss the action. So if tomorrow the Constitution were amended and took away diversity jurisdiction and Congress did away with 1332 diversity jurisdiction, hey, the federal court suddenly lacked subject matter jurisdiction, so it's got to dismiss. But yeah. So Guillard's responsive pleading is her answer, and it does not assert lack of personal jurisdiction as an affirmative defense. She has thus waived the defense, and that's Bueller versus Audio Leasing Corp., 9th Circuit, 1988, unpublished, which says lack of personal jurisdiction must be argued in a defendant's first appearance to the court, whether that be an answer or a motion, or it is deemed waived. And SEC versus Eurobond Exchange Limited, 9th Circuit, 1994, which says, in civil cases, Federal Rule of Civil Procedure 12H1 mandates a waiver of the defense of lack of personal jurisdiction unless it is raised in the answer. Even if the court looks past Guillard's waiver under Rule 12H1B2, she has forfeited the challenge through her conduct during this litigation. When a defendant initially preserves a challenge to personal jurisdiction, she can forfeit that challenge through her conduct during the litigation. That's Argonaut Insurance Co. versus St. Francis Medical Center, 9th Circuit, 2021. Guillard's conduct here departs from challenging the court's personal jurisdiction. This case started in December 2022. Since then, Guillard has appeared, challenged the clerk's entry of default, filed an answer, filed counterclaims against plaintiff, attempted to add plaintiff's counsel as parties, participated in the Rule 26F conference, that's the initial discovery conference, and sought discovery on the merits from Facebook by issuing a subpoena under this court's authority. In short, for months, Guillard happily litigated before this court. She asserted a lack of personal jurisdiction only after the court dismissed her counterclaims. A party cannot test the waters with one court and then challenge personal jurisdiction after the court issues an unfavorable decision. Guillard has forfeited any challenge to the court exercising personal jurisdiction. But on the merits, the court has personal jurisdiction. So not only did she waive arguments to personal jurisdiction, the court has personal jurisdiction all on its own. Personal jurisdiction takes two forms: general jurisdiction and specific jurisdiction. General jurisdiction, I can be sued in Utah courts. Don't sue me in Utah courts. It'd be a waste of time. But they have general jurisdiction over me. I am a citizen of the state of Utah. They don't have to find a way to exercise power over me since I live in the state of Utah. Idaho courts do not have general jurisdiction over me because I live in the state of Utah. I am a citizen of the state of Utah. I rarely pass through the state of Idaho. And generally, it's only transitory on my way to Wyoming. So they'd have to have specific jurisdiction over me. Did I get into a car accident with someone during my transit of the state of Idaho? Did I have sufficient contact somehow with the state of Idaho for them to have jurisdiction? Otherwise, they'd have to sue me here in Utah if they can't find a way to get me into Idaho. So here, Professor Scofield is saying that the court has specific, not general, jurisdiction over Guillard. So Guillard resides in Texas, so the court cannot exercise general jurisdiction over Guillard, but the court can exercise specific jurisdiction here. The court's exercise of personal jurisdiction must satisfy Idaho's long-arm statute and the due process clause of the 14th Amendment. That's citing Floyd versus W. Oilfield Supply Co., District of Idaho, 2020, which says, in Idaho, personal jurisdiction is governed by the Idaho Long-Arm Statute, Idaho Code Section 5-514, and the Due Process Clause of the 14th Amendment. Specific jurisdiction exists under Idaho's Long-Arm Statute, specifically Idaho Code Section 5-514B, and the Due Process Clause for the same reason. Guillard's defamatory statements targeted Idaho and caused damage in Idaho. Idaho's long-arm statute is satisfied if the alleged tortious activity was directed at an Idaho resident and the injury was felt within the same state. That's citing Floyd again. Similarly, for the Due Process Clause, when a plaintiff sues an out-of-state defendant for conduct that occurred over the internet, courts in the Ninth Circuit apply the effects test when the harm allegedly suffered by plaintiff sounds in court. So sounds in tort, sorry, not court. So sounds in tort. It's where is the effect felt? Where is the effect of the tort felt? Where is the harm suffered? That's citing Northwest Healthcare All Inc. versus healthgrades.com Inc. 9th Circuit 2022, unpublished. See also Panavision International versus Tupin. OE might be an umlaut O. 9th Circuit 1988, which says, in tort cases, jurisdiction may attach if the defendant's conduct is aimed at or has an effect in the forum state. And Yahoo Inc. versus La Ligue contre la racisme et l'antisemitisme. So French, the League Against Racism and Anti-Semitism. I don't speak French, but that one's pretty easy to figure out. 9th Circuit 2006 says, in tort cases, we typically inquire whether a defendant purposefully directs his activities at the forum state, applying an effects test that focuses on the forum in which the defendant's actions were felt, whether or not the actions themselves occurred within the forum. The effects test has 3 requirements. The defendant allegedly must have 1. Committed an intentional act. Defamation is an intentional tort. 2. Expressly aimed at the forum state. It was aimed at an Idaho resident in Idaho for actions in Idaho. And 3. Causing harm that the defendant knows is likely to be suffered in the forum state. Professor Scofield, while damaged in Texas, the bulk of her damage is in Idaho. Her friends and family are in Idaho. Her colleagues are in Idaho. Her job is in Idaho. The negative repercussions she feels are in Idaho. The harassing phone calls and emails she receives, the death threats she has received are in Idaho, or at least she receives them in Idaho. So, and that was citing Yahoo from above. The allegations here meet all 3 requirements. Guillard intentionally created and posted over 100 videos falsely stating that Professor Scofield had an affair with a student and ordered the murder of 4 students. Guillard's statements were aimed at Idaho. Professor Scofield lives in Idaho. The alleged affair would have occurred in Idaho. The murders that Professor Scofield did not commit occurred in Idaho. And the main community affected by the murders and Guillard's false statements, the University of Idaho, is in Idaho. Finally, Guillard knew her false statements would cause harm in Idaho. From her research online and her receipt of 2 cease and desist letters, Guillard knew the target of her defamatory statements, Professor Scofield, lived in Idaho, taught at the University of Idaho, and was suffering damages in Idaho. Next up, Professor Scofield selected a proper venue. A civil action may be brought in a judicial district in which a substantial part of the events or omissions giving rise to the claim occurred. 28 U.S.C. Section 1391b2. The 9th Circuit has ruled that when determining where a substantial part of the events or omissions giving rise to the claim occurred in a tort action, the locus of the injury is a relevant factor. So remember, Guillard argued, well, the TikTok videos occurred in Texas. I'm in Texas. Professor Scofield says she's not the murderer, so nothing involved in the case happened in Idaho. The locus of the injury. So Professor Scofield's damage occurred in Idaho. Thus, that's a proper venue. Texas would have also been a proper venue. They both are proper venues. But the plaintiff when it comes to choosing from options, if more than one option is available, the plaintiff gets to choose. The plaintiff is the master of their case. So that was citing Rogers versus Color Station, Color State LLC, District of Idaho, 2023, which itself quoted Myers versus Bennett Law Offices, 9th Circuit, 2001. In Rogers, a different judicial officer in this district recognized that a plaintiff alleging defamation felt the harm of the allegedly defamatory statements in Idaho, where she was residing when the statements were made. And this would mean that a substantial part of the acts, events, or omissions that gave rise to the defamation occurred in Idaho, and venue in Idaho is appropriate. Venue is proper here for the same reasons. Professor Scofield lives in Idaho and works in Idaho. The damage to her reputation, career, and mental health all occurred in Idaho. And Guillard intentionally made statements about an alleged affair in Idaho and murders that occurred in Idaho. Next up, Professor Scofield has stated a claim for defamation. When a party moves to dismiss a complaint for failure to state a claim, all allegations of material fact in the complaint are taken as true and construed in the light most favorable to the non-moving party. That's citing C&S Hamilton Hay LLC versus CNHM LLC, District of Idaho, 2008, as amended 2008. So, because remember, Guillard cited a case, an unknown case from the Second Circuit in 1965. And I said, that's completely the wrong standard because Twombly and Iqbal are the controlling standard now. Although they used C.S. Hamilton Hay because you're going to use a local case frequently because it's, as long as this case is in compliance with Twombly and Iqbal, it might have local standards in addition to Twombly and Iqbal. But yeah, so like I said, it's, what was it? I'm just gonna search 1965. So the second, and this is from Guillard's motion, the Second Circuit noted that plaintiffs deserved, at minimum, an appropriate and reasonable opportunity to show good faith belief that the alleged damages were reasonably possible, and the court says her statements aren't facially plausible under Twombly and Iqbal. So yeah, she was trying to argue in favor of her claims as opposed to against Scofield's claims with that. So the motion should be denied unless it appears beyond a doubt that plaintiff can prove no set of facts in support of his claim that would entitle him to relief. Accepting all of Professor Scofield's allegations as true, she has stated a claim for defamation. A defamation claim under Idaho law has three elements: that the defendant, 1, communicated information concerning the plaintiff to others, the TikTok videos; 2, that the information was defamatory. That would be false murder claims and false affair claims. And 3, that the plaintiff was damaged because of the communication. That's citing Dickinson Frozen Foods, Inc. versus FPS Food Processors Corp., District of Idaho, 2018. Professor Scofield has alleged that Guillard falsely stated in videos that she published to the public on TikTok that Professor Scofield had an affair with a student and ordered the murder of 4 students, and that those statements have damaged Professor Scofield's reputation and caused her extreme emotional distress. Those allegations satisfy all 3 elements. Guillard made her statements about Professor Scofield to everybody that viewed her TikTok videos. The statements were defamatory as they asserted that Professor Scofield had committed a crime and acts of moral turpitude, and Professor Scofield was damaged because her reputation was tarnished and she suffered extreme emotional distress. Professor Scofield has thus stated a claim. And I'd go even further. I actually would have argued damages aren't necessary, or allegations of damages aren't necessary at this point to survive a motion to dismiss, because this is defamation per se due to the nature of the claims made. So, either way. Next up, Guillard cannot seek relief under Rule 60B because the court has not entered a final judgment or order. Guillard seeks to set aside the order dismissing her counterclaims against Professor Scofield and her counsel under Federal Rule of Civil Procedure 60B4 and 60B6. 60B4 and 6. Rule 60B provides grounds for relief from a final judgment, order, or proceeding. The court's order dismissing Guillard's counterclaims is not a final judgment or order because Professor Scofield's claims still need to be adjudicated. Guillard thus cannot seek relief under Rule 60B, Wolf v. Otter, District of Idaho, 2017. Plaintiffs rely on Federal Rule of Civil Procedure 60B to support their motions to reconsider. That rule does not apply here because this court has not entered a final judgment. So, guess I was wrong there. So, sorry. Never actually looked up the case law on that because it hasn't mattered to me. But either way, it's irrelevant because even if it's a final judgment on the merits, which it is a decision on the merits and it is final, but the case itself isn't over. But even if it were, it's still a frivolous argument. It's ridiculous, which is what this next section is going to argue. Guillard's arguments to set aside the dismissal and her counterclaims also fail on the merits. If the court looks past the procedural deficiencies of Guillard's motion to set aside, it should still deny her motion because it fails on the merits. Guillard appears to argue that the court's order is void because the court lacks jurisdiction. The court wrongly rejected her legal arguments, and the court is biased for rejecting Guillard's legal arguments. The court has jurisdiction for the reasons already discussed. Guillard's other arguments fail because rehashing the same legal arguments that the court rejected are not proper grounds for reconsideration or establishing judicial bias. Citing Hannigan versus OPSEC Inc., District of Idaho, 2023, which says a party seeking reconsideration must show more than a disagreement with the court's decision, and recapitulation of the cases and arguments considered by the court before rendering its original decision fails to carry the moving party's burden. So basically that's saying Ashley Guillard's argument is, but Your Honor, nuh-uh, and that's not good enough. You have to have something new, newly discovered evidence that wasn't available to you beforehand. That would be one. So, like, it's a case I haven't covered, but someone I have covered, Delete laws, his Ironton case, DeCastro versus Wagner, when he did his motion to reconsider the dismissal and said, but Your Honor, Google's atomic clocks say that the city hall wasn't closed. So arresting me a minute before Google's atomic clocks, well, he could have, if that were a legitimate argument. It wasn't. It was a terrible argument because the arresting officers could reasonably rely on the clocks in City Hall to determine that City Hall itself is closed. The City Hall doesn't say, we run by Google's atomic clocks. If the clock on the wall says they're closed and can tell you to leave. So he tried to argue that was newly discovered evidence, but he could have brought that before the case was dismissed. Him not thinking of the argument before the case was dismissed didn't matter. That didn't make it newly discovered evidence. Same here. Except Guillard hasn't even brought an atomic clocks argument. She really is just saying, nuh-uh, and if you don't rule for me, that means you're biased. And that's not good enough. That's so far from being good enough. So, and then Mertens versus United States, District of Idaho 2011 says, the Supreme Court has recognized that judicial rulings alone almost never constitute a valid basis for a bias or partiality motion. Something other than rulings, opinions formed, or statements made by the judge during the course of the trial is required. So, if, say, Professor Scofield had an affair with the judge instead of a student, not that I'm alleging she's had any affairs, that would be bias. If the judge had an affair with one of the murder victims, that could be bias, or at least bring questions about his ability to be impartial. If just ruling against her, that's not bias. That's being a judge. One party is always going to dislike a ruling. This is a zero-sum game. When a motion is brought, one party wins, the other loses. If one party losing made the judge automatically biased for making a ruling, we couldn't have courts. That's just absurd. So, next up, the court should award Professor Scofield her attorney's fees. Guillard has again forced Professor Scofield to incur attorney's fees litigating issues that are procedurally improper and meritless. Professor Scofield understands the court's leniency with Guillard as a pro se litigant, but to defray the financial burden on Professor Scofield and to deter more frivolous filings, Professor Scofield again respectfully requests that the court exercise its inherent power and award attorney's fees to Professor Scofield. Conclusion. Professor Scofield requests that the court deny Guillard's motion and award attorney's fees to Professor Scofield, dated September 11th, 2023, signed Wendy J. Olson, attorney for plaintiff. And it was served. So that's where we stand. Like I mentioned, that was docket 50 and 51. 50 in part A, of course. 51, part 1, I meant. 51 in part 1 and 2. So, yeah. So, where does that leave us? We don't have a ruling on this yet. I'm going to go out on a great big limb here and say the motion to dismiss is going to be denied because, yeah, we've already discussed it. We just spent, between the two videos, 3.5 hours discussing that. It's untimely and bad arguments in general. So Professor Scofield wins on that. I doubt she's going to get attorney's fees now. I think there's a good chance of her being awarded attorney's fees at the end of the case. So where are we going from here? We are, next video, going to do the motion for partial summary judgment brought by Professor Scofield and the opposition, which was filed on Halloween. So, and that'll have us caught up. Imagine that, caught up. So with that, be sure to like, share, subscribe, do all that fun stuff. Visit Professor Scofield's GoFundMe. That's a good cause. And like and share part 1 if you haven't already. And if you haven't already watched it, go watch it. I mean, I told you to at the beginning. So with that, thanks for watching. Thanks for joining me. Thanks for being patient with technical difficulties. And I will see you soon to do the summary judgment motion. Bye-bye.